We're not afraid to take the tough cases.
How do you charge somebody with something that's not a crime?
You go to trial when you have to, because even though people like us like trying cases,
We're not risking anything.
ask them, "Hey, what are you doing?" His response was, "What am I doing? What are you doing? I can do this."
They don't like to be reminded of what your rights are.
In a way, you have a right to party.
I tell people all the time, the court system is complete chaos.
The first thing they should do is actually the first thing they should stop doing. Don't say anything to anybody other than an attorney about your case. Don't talk to the police about it. Don't post it anywhere. Don't go online and put stuff on social media or anything like that.
Welcome to the Iron Gavel. I'm Chris Washington, a criminal defense attorney with over 17 years of experience. Today, we explore several amazing stories of justice, stories where our hero faced seemingly impossible odds, but his clients emerged victorious because of strategic preparation and strategic defense. Today's guest is attorney Chris DeMaio from Connecticut. Recognized by his peers for exceptional legal skills, Chris was selected to the Super Lawyers from 2019 through 2024. This selection is based on reviews and opinions of other lawyers as to the quality of legal representation a lawyer provides. In his career, Chris has tried more than 40 cases and argued more than 10 appeals. Let's uncover the truth together. So, Chris, what you gonna tell us about today?
Thanks for having me. I'm a criminal defense attorney based in New Haven, Connecticut. I travel throughout the state. Connecticut's not very big, so it's not too hard to go from New Haven, Hartford, to places like Stamford and even farther east. I also do civil litigation. I've been doing more appellate work the past few years, as well as administrative type proceedings, child protection, DCF matters. Criminal law, I've been practicing for almost 15 years, and I've been doing criminal law for pretty much that entire time. That's currently what I do the most. I've tried several cases and handled in the 100, if not more.
What inspired you to become a criminal defense attorney?
I don't think there's any one thing. My father was an attorney. He's retired now. He really didn't do criminal work. He was a general solo practitioner for the first half of his career. But, through him, I was exposed to law, going to court with him on days I had off from school. In high school, I gravitated toward civics and social studies and a lot of the activities related to that. I did mock trial and really enjoyed that. I liked getting up, making a case, being able to question, cross-examine witnesses, and make an argument, and tell a story too. I've done a lot of writing and always had an interest in film and literature. So that's kind of a way to tie it together. But I'd say probably throughout high school when we were studying constitutional law and rights, I really became fascinated with civil liberties and constitutional rights, especially First Amendment, Fourth Amendment. And as I got into law, first I saw law as a way to be a player in that field in society. And when it comes to getting into constitutional rights, criminal law is we deal with it every day. And also, I just found the subject matter interesting. Maybe I watched too many movies and read too many books, but I just find murders and larcenies and self-defense, all those things, a bit more interesting than some of the other parts of law.
Like, I agree. I tell people I do personal injury all the time, but criminal cases are more exciting because everyone is different. Every single one.
But here's the thing, you know who else agrees with us about it being more interesting? Everybody. You look at TV shows. The show is Law and Order, not mergers and acquisitions. They probably make a lot more money than we do. Well, it's probably more than I do.
That's probably true. If they're doing mergers and acquisitions, they're certainly making more money than we are doing criminal defense work.
But also what I like is it's really where you could represent people. People who are in jams, in trouble, and help them out of it. You often have tangible outcomes and results in a criminal case.
So what would you say a typical day is like for you in your practice, specifically with respect to representing people accused of crime?
I guess the only thing typical about a day in my life with my firm is that there are no typical days. So which means that every day has something unexpected. It could be I got the same point. You tend to expect clients who are running late to court and waiting on discovery. So in criminal cases, again, here in Connecticut, we have two types of criminal courts, two levels of court. We have GAs and JDs. GAs are geographical areas. JDs are judicial district courts. Those are the courts for higher level crimes. Most GA practice is, high volume. You get to court in the morning, talk to the state's attorneys, the prosecutors. Sometimes you have to meet with judges for pretrials. Then you corral your clients, tell them what you're doing that day, unless you're continuing the case off the record, and then you go in and do it. And that's kind of the run-of-the-mill day-to-day things. It could be having discussions with prosecutors to reach an agreement or something else on a case. Could be setting the case down for a hearing, applying for a program, entering a plea, or pushing the case to trial. A lot of things are done really just in personal discussions with the prosecutors. And sometimes we have judicial pretrials in Connecticut. I know some states don't.
We don't have that. What, judicial pretrials?
Say you can't reach an agreement or there's some issue that needs to be addressed. The defense attorney and the prosecutor will often meet with the judge in chambers. And the judge might put his or her own offer on a case. If he pleads, here's what I'll give him, that sort of thing. Or address other issues. So sometimes before you file a motion, or even after you file a motion, before it's heard, there's a discussion on where it might be going. Like, is the state going to contest this motion? And then as cases get closer to trial, there are further discussions. So there are some judges and some dockets where the judge is involved in the discussion. I know a lot of states, I think, don't have that because you have, or I'm not saying you, but it might be a county or a district where there's really one or two judges.
We do have a lot of those in a lot of our smaller parishes. Actually, the parish I grew up in, there's two judges. We don't have counties where other states have counties, we have parishes. So the parish I grew up in, there's two judges, but there's a lot of parishes that have a small number of judges. But here, they don't really get to decide the sentence. It's really up to the district attorney. So a lot of times, in most places, there are a few places where the judges will give input, but there's no authority for them to determine what the sentence will be other than a verdict in a trial. Then the judge imposes the sentence. But if there's a plea negotiation, typically it's between the prosecutor and the defense attorney. And the judge does have the power to reject it, but I've only seen that in a handful of cases in my entire career. They have to accept it, but they don't really get to decide what the number is. That's up to the DA's office.
Yeah, I mean, here, a lot of times you will reach an agreement with the state and the judge will take it. I have seen times when judges heard it and say, oh, no, I'm not taking that, and they'd kick it back. It's rare, but it does happen. But other times, the state decides the charge and might make a recommendation, but the judge will say, I'm not doing that. Obviously you run into some charges with mandatory minimums because then the judge is stuck with whatever charges is filed.
What's the penalty for murder in Connecticut?
So we don't have the death penalty anymore. So murder, you could receive a life sentence, which is up to 65 years.
I always like to compare. We have first degree and second degree murder. The penalty is life without parole. Manslaughter, the 15 to 40 with the firearm enhancer. And then we have negligent homicide that carries 5.
We don't have degrees of murder. I mean, there's murder, and then there's murder with special circumstances, what used to be capital murder. And the penalty for that is life without the possibility of parole. Although murder isn't parole eligible anyway, just that with special circumstances, it's the rest of your life, no parole at all. Whereas with murder, you could conceivably get less than a life sentence, but still not parole eligible.
Before we jump in, I got one more question to ask you. What would you say sets you apart in your field as well as your firm?
We're not afraid to take the tough cases. People hire us often because they want their day in court. And, it's one thing to take a tough case. It's another thing to take a case that, many might see as impossible. We'll take it for you. We'll go the distance on it. And there are no cases and no courts where we're not afraid to go. But we're also realistic. And we'll level with people, with all our clients, as to what they could and should expect. You might come to me with a case that you say you're not going to plead, you're going to take the trial, and I'll tell you what the evidence shows and what I think it will show and what I think your prospects are. Yeah, you might want to reconsider the direction you go in. With that said, we represent our clients and we do what they need us to do.
You wanted to actually talk to me about several cases, I think 3.
Yeah, in terms of dismissals, I had some interesting cases that I got dismissed without going to trial.
Today, I want to hear about these cases that you were able to get dismissed. Pick one and tell us about it.
Motions to dismiss are much more common in civil litigation. There are more issues involving jurisdiction than there are in criminal cases. And it's an underutilized tool in criminal defense, especially here in Connecticut. A motion to dismiss is often used for constitutional issue, a statute of limitations issue. It would be a jurisdictional defect. It's not usually used for factual issues, insufficient evidence. Most courts will take the position, well, that's what trials are for. Even though you might have a case that's really weak and if there's no probable cause, it shouldn't be going to trial in the first place. We're also limited to when you can use them. If it's a case that resulted from warranted arrest, if you actually can't file one for insufficiency of evidence because the probable cause was found, you have to find the right issue. And I found a few. Like one of the reasons why I filed them was kind of just to make something happen. Show the state in the court, hey, here's what my case is about. Here's why I shouldn't be prosecuted. And I'm on top of it. The one case I had, probably my favorite one, was when we discovered through research that the law my client was charged with violating wasn't actually a criminal charge.
How do you charge somebody with something that's not a crime?
It was at one point. My client operated a hookah bar and they weren't licensed to sell liquor. Acting on some tips, raided the place, and they had set up a controlled buy of a cocktail pouch. And when the transaction was made, they raided it. They seized various bottles. And he was charged with selling liquor without a permit. And the statute billed it as a misdemeanor, punishable by, I think at the time, up to 30 days jail. He denied it. Our defense was that he had to do with it, no knowledge. It was just a waitress selling it on the side. He refused to plead or take any offer. So the case went on the trial list. And as I was preparing for trial, I checked all the updated statutes. This particular statute was one of those, I call them a roadmap statute. It would have the offense shall be punished in accordance with the penalties established in some other section. And then you go to that other section and it's sending to a third section. And the third section, again, at one point had said, like 30 days in jail, making it a misdemeanor. Well, that section had actually been updated or amended by the state legislature to, just made it an administrative sanction. It shall be subject to, an action by the Commissioner of Consumer Protection, something along those lines. So it basically made it into an administrative proceeding where if you sold liquor without a permit, you no longer faced a criminal penalty. It was at most fine, and even then, an administrative fine. So at that point, it was no longer a crime. Don't know what the legislature was thinking when they changed that. It might just be one of those, they amended one section, and because this statute had a cross-reference to another penalty provision, it wound up modifying that statute too. But anyway, my client was no longer charged with a crime, but the penalty was an administrative sanction.
How did you actually go about getting the charges dismissed?
That's where I filed a motion to dismiss on jurisdictional grounds, that it was not properly in court. So I filed it. The state's attorney looked at it and said, "Oh, I need to research this." And I said, "Well, you need to research. It's right there."
I did the research. I did it for you.
We continued the case. I want the prosecutors to do their research, and they did just that. So the case was continued. The motion was then called, and the state didn't oppose it, saying, looks like it really is not a criminal charge anymore. They wanted to nolly it, but I asked for the dismissal to be entered, and they didn't object. That got dismissed.
So tell me your client, what was his or her reaction when that happened?
He was pretty happy. He didn't like that it took as long as it did to get to that point. It was one of those, well, why was I even arrested in the first place if this wasn't a crime? It was one of those things, the statute was amended right around the time he was charged. So I really think it was a matter of nobody was working with an updated statute book. And then by the time the case was on the trial list and we were getting closer, everything had been updated to the 2022 or whatever volumes we were using. Because I admit I did not catch it the first time. When it came in, I saw that original penalty. I guess the lesson is always check your statutes, make sure that they're current.
Look, these legislators change these statutes every year, and I always tell people, I'm not sure they actually read the law that's already on the books before they make these changes. Because it takes us to discover that, like, hey, this statute that you're pointing me to has been repealed or modified, and this doesn't make any sense. But they miss it every year.
I didn't bother looking into the legislative history to see what the floor debates were in the assembly on this thing, if there were any. But my guess is they, amended one thing, maybe streamline the code, and it had the effect of taking out that criminal penalty. Maybe they fixed it since, so don't take my advice. Don't rely on me and opening up a speakeasy in Connecticut thinking you can get away with it. I'm just telling you what happened in my case a couple of years ago.
Tell me about the next one.
This goes back to, I think, 2018. A client came to me saying he was arrested for throwing a party. This young man, who actually wasn't as young as his activities would suggest, happened to live in a house that was located near one of our state universities. He was not a student at the school, but he somehow befriended some kids who were, or they befriended him because he had a nice house next to the campus. So he'd throw parties, and a lot of these kids would show up. Again, he was a bit older than they were, but not a lot. So it's kind of like the movie Old School. That's really what I thought about when he came in. And there were a few calls. And then finally, I guess the one got out of hand, and the neighbors and local police just had enough. And they arrested and charged him with 2 counts, permitting minors to possess alcohol, which is a crime. I think it's breach of peace. He was saying, like, what? Like, I just had a party. Like, wait, you can't do that? And that's kind of when I was kind of half joking. And I said, you do have a right to have people over your home. You have a Fourth Amendment right. You have a First Amendment right to free association. And he's like, yeah, I do. I said, you have those rights, and in a way, you have a right to party. He signed up, and the state, they weren't pushing it too hard, but they also weren't willing to let it go. I think in large part because they happened to be the court for that city that had the state university.
And I'm sure that's quite common with a college nearby.
That should be what you expect when you move into one, honestly. The state was willing to just drop it or dismiss it. They wanted him to use the diversionary program, and he'd get a dismissal out of it. But he just refused to do it. He said, I didn't do anything wrong. I'm not doing it. They're either dropping this or we're trying it. I said, all right, we could try this. And I did think it was a triable issue because the police pretty much went in, raided the house, sent everybody home. They didn't really do any investigation. They didn't ID anybody. They didn't seize any beer or liquor or anything like that. This was before body cams. It's like, how could they prove that any of these kids were under 21? They couldn't. How could they prove that they were drinking anything? They didn't seize anything. There are no pictures of anything. It was a pretty thin case from an evidence standpoint.
What did the police actually do, if anything?
The police showed up at the house, kind of like, oh, it's a party, like, get out of here. Like, they threw everybody out, and then probably the who owns this place or who lives here, and they saw my client, and they knew him, like, oh, you again. And then they arrested him. And then the breach of peace was actually, that's a dicey one, too. Like, what peace was breached? Like, there's a party. Maybe it was loud. That's about it. Actually, it's important to explain how the trial process works in this state. And maybe it works differently in Louisiana. But in a lot of cases here, when you can't reach pretrial resolution, the case goes on the trial lists. It doesn't usually get a date after that. It goes on the lists, and then you're on notice for when it gets called in. The case could sit on the trial list for a short time, or it could sit on the trial list for a really long time, depending on how busy your court is and what level of priority your case is. So we put the case on the trial list, I'd like to say it was probably in 2019. That sounds about right. So the case sat on the trial list, the misdemeanor case that probably no one's really thinking too much about. And it just sat and sat. And then the pandemic hit, and even less was getting done in court.
Almost nothing, essentially.
I figured, like, all right, we get called in at some point, and the case would either work out, the state would just drop it, saying, oh, we're not going to try this stupid college party case. We would try it, and it would be a fun time.
Was it going to be a jury trial, a case like that?
It could have been. Both charges were misdemeanors. You could get a jury. And
here in Louisiana, you don't get a jury for misdemeanors.
Can you be sentenced to jail without a jury?
A misdemeanor carries up to 6 months in jail.
The Supreme Court said that, I think, up to 6 months. I mean, Connecticut, a misdemeanor carries up to 364 days in jail. And not a year, a little less. But you get a jury for anything that carries jail, period. So it would have been a jury trial. And again, the case was just sitting on the trial list. And then during the pandemic was just nothing really happening. I figured, well, let's go back to some of these cases I have just sitting. I've been working on it. I'll file a motion to dismiss, and maybe it'll get scheduled for something, or at the very least, when the case does get called in for trial, we have one more chance at getting it dismissed before picking a jury. Now, I remember getting an email from the clerk saying that the judge wanted to schedule it for a pretrial. Again, the grounds I alleged in the motion to dismiss were insufficient evidence because there just isn't any evidence that, as I said before, that anyone there was underage because no one was identified, and B, that none of the drinks were seized or tested. And then the breach of peace actually required a bit more argument. But breach of peace is a specific intent crime. You have to have the intent to inconvenience, annoy, or alarm. And for any of those things to amount to breach of peace, and just none of the statutory subsections fit him in this case. He wasn't obstructing a roadway. He wasn't engaging in violent or tumultuous conduct. They didn't hit anybody. So we actually didn't even argue the motion to dismiss. The judge called the case in, looked at it, turned to the prosecutor and said, why is this still here? And made them drop it. So this actually was not a dismissal. She just turned to me and said, all right, they're going to drop it. Don't ask for a dismissal. So the case was nollied, meaning the state didn't prosecute it. Procedurally, the way that works, when the state drops a case, that's a nollie prosequi, and that becomes a dismissal in 13 months. So his case was dropped. 13 months later, is dismissed by operational law.
Is that a situation where they're sort of just hanging it over your client's head? Hey, during this 13-month period, if you get in trouble, we're going to refile this, or no?
No, they really don't. I mean, as soon as it gets nollied, it disappears from the docket. The only time you see a nollied charge refiled, and it's very rare, would be if somebody picked up something else related to it. So it was one of those, all right, we're going to nollie this case, but don't come back here. You might see that in a domestic, and then, all right, this is back, and they'll refile the other one, but it's very rare. I've only heard of it even happening a couple times. I think other times the state would nollie a case in exchange for something that should have been done and then wasn't done. But no, they don't hang it over at all. I think they close their files and put them in a stack of nollies and ignore them for 13 months and then ignore them even more after that.
So cool. So your client, when his case was nollied, tell me about his reaction.
So that was done. That was a virtual proceeding. He wasn't even there. It was just a virtual pretrial, and then they entered the nollie later that day. So I think I just emailed him, and he was happy, and that was that. He was interested in pursuing litigation.
No, those cases are extremely hard. I've taken a couple, one for sure, to the U.S. Fifth Circuit Court of Appeals, and I lost at the trial level. I won at the intermediate appellate level, and then when I went to the Fifth Circuit, they threw me out of there. So we lost the case. The next step was the U.S. Supreme Court, and the case didn't really have that kind of value. My client was a former University of Miami linebacker. He was a big dude, and he was pulled over by a state trooper while on his lunch break. And the state trooper was 5'2" or 5'3", and this former linebacker was like 6'4", and he was a big dude. So the guy has his hands behind his back, and he's asking the state trooper, he's saying, like, what's my cause? What's your reason for stopping me? And while the guy is kind of like turned with his back facing the state police, with his hand behind his back, he gets tased. And there are some bystanders that see it and say, they start yelling at the state trooper, why the hell did you tase the man? He had his hands behind his back. Look, we took it up and we lost. And I stopped doing 1983 cases for the most part after that. I've won some, but they're so hard. It almost has to be like clean, a perfect case. So we got one more case you're going to talk to us about today.
This one's relatively similar actually to the one you were just describing. That particular client, again, he insists he was not drunk. I'll take his word for it. I wasn't there. All I can say is that this was in an area, in a bar and club district. He had been at a bar watching an MMA fight for a few hours that night, and he stepped out on the sidewalk at around 2 a.m. When bars were letting out. There were police who were just on the street patrolling, and he was watching the police. He, being a concerned citizen, he did not like that some of the police officers were talking to young women who were coming out of bars. So he started courting them with his phone, and one of them asked him, hey, what are you doing? His response was, what am I doing? What are you doing? I can do this.
They don't like to be reminded what your rights are.
One of them even said, okay, well, you're right. You could be there. So yeah, he continued recording and taking pictures. But then he also was continued to speak to them. Like, yeah, you're right. I can be here. And you shouldn't be doing that. And then it led to, other cops started closing in on him. And he continued to talk to them. And then they said, all right, just, just go home. Like, oh, yeah, I'm waiting for my cab. I'm waiting for my Uber. And just kept going on. And he was saying, I can be here. You can't tell me I can't be here. Using some profanity, which they didn't like.
Doesn't the law allow you to use profanity with respect to the police?
It does. He wasn't doing anything illegal.
Look, we know it's not illegal, but what happens when clients use profanity?
Well, I'll tell you what happened when he used profanity. The police were about to walk off, and he was, going in the opposite direction. Just, okay, I'm going. And like, okay, go home. And then as he was leaving, he said, too fucking easy. And I don't even know why he said that. He didn't direct it to anybody. And one of the cops just grabbed him and brought him to the ground. And then he was arrested, charged him with also breach of peace, interfering, and they took him in. He was another one that they wanted, the state wouldn't drop it from the get-go. They wanted him to either use a diversionary program, which gave him dismissal, but you have to burn the program. He'd also, or they recommended an infraction. So, a fine for a non-criminal matter. His issue was, and he was right for this, as you know, we just talked about 1983, and for usually civil rights cases, for false arrest, malicious prosecution, the criminal charge has to terminate in your favor. It has to be a nollie, a dismissal, an acquittal, but you can't do anything in exchange for it. So as you know, if he had used a program, if he had paid a fine to an infraction, made a donation, done community service, he wouldn't prevail in a civil case. And he was on that from the beginning. I'm suing these guys for violating my rights, for arresting me, for wrestling me to the ground, injuring me. So he wasn't taking anything. He hired me when his case went on the trial list. And it was, again, so that particular court would, again, you have all these cases on the trial list. They'd call them in, I think it's every month, whether it was the fourth Tuesday of the month or whatever it was, they had one day and they'd call every trial list case in for almost nothing to happen. It was really just attrition. Hopefully they'd call cases in, defendants wouldn't show up, they'd be FTA'd or rearrested. Maybe some cases would plead out, maybe one, few would go to trial. So that's the other thing about how the trial list works. Again, in this court, you would be put on the list. They'd call in a bunch of cases. I think at the time, they were calling in 70 or 80 cases. And then they would just pick a few to go next door and pick a jury. A true jury call would be they call in a bunch of cases, they have a panel of prospective jurors, and then the lucky one goes. He's a client that was, unlike a lot of people that tend to wait out their cases, he wanted to go to trial right away. So we filed the speedy trial motion. It was actually denied.
What is a speedy trial motion and how does the judge deny it?
I think in a lot of states, as you know, there's a constitutional right to a speedy trial. What qualifies as speedy is
never fast enough for the client, I can tell you that.
It could be a lot of things, but the states have a lot of control over how cases go to trial. In a lot of states, you have to waive your time or waive speedy trial rights. Is Louisiana one of those where there's a speedy trial statute that requires every case to go to trial within a certain time period? You have to waive it?
No, ours is a little different. The cases will linger. Now, if somebody files what's called a 701 motion, a speedy trial motion, and they are not incarcerated, there's no remedy. If somebody is incarcerated and they file a speedy trial motion, they have to be taken to trial within 180 days unless the prosecution can show good cause, whatever the hell that means. The remedy in that situation is that if they don't take you to trial within the time limit, you're relieved of your bond obligation. So that's a way for guys to get out of jail. But if you're out of jail, there's no real remedy.
So there are some states where you have to waive time. I think New York might be one, maybe Florida. Connecticut's the opposite. It's, again, similar, I guess, Louisiana, where you have to demand a speedy trial. Our statute is if you're in custody after 8 months, you can file a speedy trial motion. And if you're eligible for a speedy trial and it's granted, you have to be brought to trial within 30 days, which means jury selection must start within 30 days. If you're not in custody, it's after 12 months you can move for a speedy trial. And then the same thing happened. The remedy for not being brought to trial within 30 days you can move to dismiss. There is excludable time. So, it's not of that initial period of the 8 months or the 12 months, some time doesn't count toward it. So what's supposed to happen when you file a speedy trial motion is that the clerk calculates the time and says, oh, actually, when you factor in excludable time, he's only been in custody for 6.5 months. It's not ripe yet. So that's what they're supposed to do. And then if a speedy trial motion is granted, excludable time periods, so unavailability of defense counsel, other types of good cause. So with this particular client, he wasn't in custody. Maybe a day after, 12 months after his arrest, he emailed me saying, I want the speedy trial. I filed one. What usually happens, what's supposed to happen is the clerk gets the speedy trial motion, tells the judge, and they call your case in to address the motion. In this case, the clerk said, we'll just do this the next jury call. We waited a while. They did the roll of cases at the jury call, and I wanted my motion heard. I said, well, we filed a motion for a speedy trial. And the judge looked at the client and said, he's not in custody, it's denied. And then he said, but you know what? You can go next door, and if the case that's picking right now doesn't go forward, then you guys are up. It didn't happen. That was early 2020. We got called to one more jury call. They put us on the hot list. So I think they said, all right, these 4 cases are coming in to start trial. And then the pandemic hit, and nothing happened for a while. So with that one, I moved to dismiss on 2 grounds. One was actually on the speedy trial, because I argued that the court improperly denied the speedy trial motion. It never calculated his time. And because, it didn't do that and he wasn't brought to trial within 30 days, the case should be dismissed. So I filed that motion. I also filed some First Amendment issues regarding the fact that he was arrested for swearing. You'd think that with courts limited, maybe they'd be hearing dispositive motions during the pandemic. No, they didn't. The case sat for about 2 years. And then in early 2022, the case was brought in. I mentioned, hey, we have a motion to dismiss, and they got referred to a judge to hear the motion to dismiss. And the day before we were supposed to argue the motion to dismiss, the state's attorney called me saying, yeah, I'm not going to oppose your motion. I watched the video. That was that. We went in the next day, took the dismissal, and moved on. That video had existed 2 years before. Could have resolved that case a lot earlier, but at the very least, we did. Talked about speedy trial. Maybe we would have won that motion, but that motion didn't get heard in a speedy manner.
So that's cool. So a lot of times, people think all the glory comes in going to trial, getting found not guilty, something, TV worthy happens in trial. But the reality is it's actually pretty darn rewarding to be able to get cases dismissed prior to going to trial, because now the client doesn't have to sit there with his life and freedom on the line. You're able to work something out in advance of trial.
I agree. I'd like to get a charge nollied. Just say, drop it. Let's be done. Then dismissals are great. You go to trial when you have to, because even though people like us like trying cases,
we're not risking anything. I like trying cases, but at the same time, it's not my freedom that's on the line. So I always tell my clients all the time, I said, look, this is what I do. I enjoy doing it, but you have to decide if you want to take the risk or not.
I think this is a good case, and I'm not saying that because I want to try it. I can't tell you what 6 people I don't know are going to think about it. You could pick a jury and think, hey, those people are pretty good, and then you get a verdict. Again, the way our system operates, it encourages that almost to a fault. In a lot of ways it pushes, pleas. And
some cases should be tried and people take pleas.
I think so. I think a big part of that is because of mandatory minimums.
There's a fear factor. Even an innocent person in a lot of these situations will take a plea deal because the risk is too great.
The pain of the process. It's going to court every 4 to 6 weeks for a year, missing work. You have charges pending that people can look up online and see. So there are a lot of reasons why people might just want to be done with something, even if they have a good case.
So I want you to share one lesson from your career that you think everyone should know about the justice system. You can give me more than one. Try to pick the top one.
Calling it a system assumes that it's some sort of organized thing that's all working together. It doesn't operate that way.
I tell people all the time, the court system is complete chaos almost everywhere you go, except for federal court. Federal court is organized, but state court, total chaos?
I'd say it's probably the fact that there are a lot of moving parts. And, a lot of courts, they're doing it probably as good of a job as they can, managing an almost impossible task. We have a lot of moving parts. It's a system that's made up of people. So defendants are people. They're not just paper filed in the court. So you have witnesses, you have police, you have prosecutors. And the law might say one thing, but what somebody is actually going to do isn't always that. And so much of it is dependent on what somebody else thinks. Prosecutors have a lot of authority in what cases go forward, what sentences get imposed. There are a lot of statutes that are similar to each other, but one carries a mandatory minimum and the other doesn't. And it's really the prosecutor that decides which charge to file. Like in terms of drug cases, we have two statutes that look very similar. One is much harsher than the other. If the state's attorney isn't coming off the mandatory, you might be looking at 2 years at least. Gun charges too. Most gun charges have a mandatory element to them. So you're often depending on what charge is the state going to push or not. And if the state isn't coming off the mandatory, that's your baseline. What the judge might do, you have to figure that out. And that's just going beyond what witnesses might say and what jurors might do. The one thing about the justice system is that it isn't any one thing. It's, even within a courthouse, you have different offices, like family relations, you have probation, you have the bail commissioner. And a lot of stuff is happening all at once, at least in our courtrooms.
That's true here, for sure.
Conversations going on. Marshals are bringing people up and down from a lockup. You have sidebars. You might be talking to one prosecutor while another one is calling cases. So yeah, I guess that's probably what I would tell people, that it's a system in the loosest sense of the word.
That's right. It's not like an assembly line where they make cars. It doesn't run anywhere near as smooth as that.
Probably shouldn't be either, though, because, not factory produces the same thing. It might have a lot of cases that are stock cases. They're all kind of similar. They fit within certain criteria, but they're individuals, individual people doing individual things.
I'm glad you say that, because I don't know if this has been your experience, but part of my experience has been clients who are facing a charge. They always want to look at what somebody else got as the penalty for, in their mind, is the same charge. But like you say, no two cases are exactly the same.
Yeah, I've had that. I think we all have. Well, that's the other thing I probably want to say to people who aren't familiar with the criminal justice system. There's an idea, I guess you see it through TV. We're always getting our client, and I hate this term, we're always getting people off on technicalities. It doesn't happen. You're not getting charges dropped because someone used a comma instead of a semicolon, or something was typed on the wrong size paper. None of that. As for actual suppression issues, Fourth Amendment, Fifth Amendment, those aren't technicalities. That's the law. And even that's not a routine thing.
I would say more times than not, you get ruled against.
It's a pretextual stop, and it turned out the court says the police officer was allowed to do that because he was justified, and the pat down for his own safety or something like that.
So if someone is watching this and they find themselves accused of a crime, in your opinion, what's the first thing they should do?
The first thing they should do is actually the first thing they should stop doing. Don't say anything to anybody other than an attorney about your case. Don't talk to the police about it. Don't post it anywhere. Don't go online and put stuff on social media or anything like that. Pretty much everything that you say to somebody other than an attorney
can and will be used against you. And those are real words with meaning. I wish people would heed them more often, but in a lot of cases, they simply don't.
So I guess rule number one, don't say anything about your case to somebody who isn't your attorney. Rule number two, call an attorney. And that means actually call a real attorney. Don't use Google law to litigate your case yourself.
Right. I agree with that 100%. 110%. What reforms do you think need to happen with respect to the criminal justice system? And you can speak on Connecticut or you can speak on the U.S. as a whole.
Connecticut's a really small state, but it's a small state with lots of local courts and customs. So I think standardization for certain things would be good in terms of discovery, a standard discovery process. What frustrates me more than a lot is, I do civil work too. And the civil rules of practice are, at least in this state, and actually federally too, much more structured. Like discovery is a real thing in civil litigation. In criminal, yeah, you have discovery rights, but a lot of it's dependent on what the state decides to turn over to you.
And then there's no real penalty. I do personal injury as well. So if a defense lawyer doesn't answer discovery within whatever time is allotted, they can be subject to sanctions and all sorts of things. I have never seen a prosecutor sanctioned for not turning over discovery in a timely fashion.
Courts have done a pretty good job pushing them a bit more, but I just think there should be a standard timeline, whether it's a local standing order or scheduling order, where upon a certain amount of time after charges are filed, the state must turn over discovery. There are some courts, some states' attorneys' offices that used to, and still are, very good at, you file an appearance, they'll send it right over to you. Or when you get to court on your first date, they have a copy already in their file for you to take. Then there are others where that isn't the case, and you have to file a request, and then you have to pick it up in person. And so, why wasn't this done? Why isn't this done as a matter of court? Who doesn't want this stuff? So I think some sort of standardization with timelines would move things more effectively. Actually, I do think that fewer mandatory minimums is a reform I'd like to see.
I would love to see that.
Or at the very least, maybe instead of having hard mandatory minimums, have some, what I would call a soft mandatory minimum where a court could find mitigation somewhere. We have a few statutes like that where 1 year of which cannot be suspended unless court finds mitigation. That'd be pretty helpful. Because it is, you get in these situations where, you're charged, it might not be a strong case, but it's the right charge and someone's facing 2 years automatically. I think that would move things. It's less about reforms and more about, cases and decisions. I have a lot of criticisms about, I think the Fourth Amendment has been watered down in a lot of ways.
I agree with that.
I don't think there's anything that can necessarily be addressed statutorily, but I think it does need to be addressed through cases, through litigation. That starts with us.
What is the Fourth Amendment, though? Because some people may not know what that is.
So the Fourth Amendment, the right to be free from unreasonable searches and seizures, the warrant requirement, and all the exceptions to it.
That's right. These no-knock warrants, which are dangerous for everybody involved. And then in general, people's rights just being ignored by law enforcement in a lot of cases.
Then Fourth Amendment issues probably more often now come up with motor vehicle searches. You see a lot of, I won't say abuse of the practice, but you see a lot of police officers taking advantage of protective sweeps, pat downs for weapons, protective sweeps of cars to find other things. And there's a lower standard for a pat down search, as you're under the Terry stop requires just reasonable suspicion, and they'll do a pat down and say they feel something that might feel like a weapon, even though it's soft and feels more like a bag of drugs. And they pull that out, and that's upheld as a valid search. And I've seen it with cars. You used to need probable cause to search a car, but you don't need probable cause to do a weapons sweep. And they'll do a weapons sweep of the center console, the glove compartment, and not find the gun or a knife, but they'll find some drugs. So that car just got searched on a lower standard, one below probable cause. I think those are issues that are really worth pursuing. Another thing that I think is worth pursuing, and we've been using, or we actually have had an advantage of more of body cam and dash cam, so far more than we've had before. I know we have a statute that requires police to use them in most circumstances, but there isn't really a penalty when they don't, if the cameras turn off or aren't turned on. I've litigated it. I haven't had any success yet, but I argued in one case for exclusion, that if something should have been recorded and for some reason or for no reason wasn't, then the officer shouldn't be allowed to testify to that.
Interesting argument. Did it work?
I didn't get that, but what the court did suggest was an adverse inference.
Okay.
So, that's something.
Like a soft pitch. We're not going to give you the ultimate request, but we'll let you argue and essentially say they should have recorded this and they didn't, and because of that you should not believe them, or something similar to that?
Because it wasn't recorded, the recording would show something else. I haven't actually done it yet.
There's one case in my career that I simply will never forget. And the guy's name was Ramad Serial, and he was found guilty of armed robbery. The allegations were that he went into a store, and while in the store, he jumped on the counter, placed his hands, placed his feet, so there should have been fingerprints, DNA, footprint, all of these things to identify who the robber was. The robber had on a mask that came right above the eyes and right below. And the only witness, the lady behind the counter, said she recognized my guy because of his eyes. Now, my client was black. Most black people have brown eyes. We don't have blue eyes and green eyes. Rarely do you find that, in African Americans. Anyway, the plexiglass that the robber jumped onto and left all of this evidence that should have been collected and preserved, the lead detective said he lost the glass. He lost the plexiglass, and our only remedy was an adverse inference that they lost the glass because the glass would have proven that the DNA and fingerprints didn't belong to Ramad, they belonged to somebody else. And the jury did not accept that, and he was found guilty. And I do believe that that's an innocent man that went to prison. It was more than 10 years ago. I mean, it's the one case that sticks with me because I do believe he was innocent, and I believe he went to prison because this police officer did not preserve that evidence.
It was one thing when it was tangible evidence, but again, now we have to be on the lookout for that being done with video. Video is really good when you have it. When I was arguing to a prosecutor about this, I said, what's the big deal? You could still cross-examine the cop. Yeah, I know I could. But look at it this way. And this was a case where one of the issues was a motor vehicle collision. The cop said that my client rammed her cruiser. We didn't have her dash cam. And her dash cam, I thought, would have been pretty helpful because it would have shown whether she accelerated, but we didn't have that for reasons that the car didn't record it. The analogy I used was, what if I told you that I had a client with an alibi, that he was at home at the time of a murder. He was at home watching TV. He has surveillance footage of his house. And we had surveillance footage for 3 hours, except for the 15-minute window when this crime occurred. What would you think about that? You start wondering, hey, why don't you have this? Why aren't you giving us this great video of your client's alibi?
That's a good argument. I'm going to have to use that.
Use whatever you can. I hope somebody is able to win with some of these things. When it's something that's missing and it just so happens to be a critical piece, it has to be more than a coincidence. Of all the times the camera wasn't working, it was then. We have an hour and a half of them driving around the neighborhood, but we don't have the 30 seconds of when you approach the car. A little convenient.
I actually looked this up. You told me Connecticut was a small state, 3.6 or 3.7 million people, somewhere around there.
We have over 3 million people in a small area.
We have 4 million as the population of Louisiana.
I guess that sounds about right.
I think we're a fairly small state, I would say. Before we go, what I would like to do is let you tell people, especially in Connecticut and Wisconsin where you're licensed, where they can find you if they need you. Because although there's a lot of lawyers, I think we can both agree that there's a shortage of quality criminal defense lawyers who care about what they do. And that's just a fact. So if somebody is in your area and they need a lawyer, how do they find you and your firm?
Well, the firm is Pattis & Paz, where we're in New Haven. So our website is pattispazlaw.com, PATTISPAZLAW.com. Contact us through there. And my email address, cdematteo, CDEMATTEO, at PATTISPAZLAW.com. We're in New Haven. We cover the entire state. I'm licensed in Wisconsin. I currently am not taking cases there. But hey, I know a lot of great people from law school that are. So if you have a case in Wisconsin, let me know and I'll pass it along. But for now, it's just here in Connecticut.
All right, well, thank you. It's been a pleasure, Chris. I'd love to have you back on in the future to talk about some other cases. And I appreciate you doing this. I know you guys, it's 9:22 in Louisiana, so I'm assuming it's 10:22 in Connecticut.
It is, yeah. It's one of the only times have free to get things done.
You have a kids, a family. I can relate.
All right. It's been great. So I'll come back anytime. The two of us find something to talk about.
Thank you for watching today's episode. I truly believe you will find and hear a lot of nuggets in this episode that you can take with you and use in emergency situations where your rights are being violated or it appears they may be violated. If you do find this episode entertaining or useful, please hit the like and subscribe button, and also please share it with any family members or friends who could benefit from this information. Have a good night, folks, or have a good day. Until next time, the Iron Gavel signing off.